Hey, everybody. Hello, hello, hello. How's everybody doing this evening? Hi, everybody. Let me get to my chat here. Where y'all from? Tell me where y'all from tonight. I am reporting live from Tula, Mexico. Still in the area. I had to get through my live show before I can make it back home. It's good to be with you all tonight. Oh, y'all are so sweet. Yeah, you have been missed. Thank you so much. Thank you for what you do. You rock. You rock too. You rock too. I'm a little tired tonight, so y'all forgive me, but I am present. Tell me where y'all are from. Let's see. Oh, wow. Washington. Whoa. I'm way far from you today. Check out the palm tree. Yeah, I'm in Mexico. It's beautiful here. It's absolutely gorgeous. I can't say enough about it. Hello from NC. Hey, homie, 910. I'm in the 910 right by Camp Lejeune. Oregon, somewhere I've never been, but I've got to get. I've got to get to Oregon. I always wanted to go. I hear it's beautiful. Benton Harbor, Michigan. Never heard of it. Hi, Mr. Reggie. The great state of Texas. It is a great state. And I'm going to be honest, I didn't realize Texas had so much farmland before I actually went there like 10 or 15 years ago. I was like, wow, there's a lot of cows and a lot of land. Columbus, Ohio. Bernie, I know who that is. I know who that is. Augusta, Georgia. Wow, thank y'all for joining me tonight. It's a pleasure to have you with me. Alabama, Florida, Mooresville, NC, Atlanta, California, South Carolina. Hope you're enjoying your work. Thank you. I am, but it's been a work. I've been working the whole time, so not really a vacay, more of just visiting because I missed the flight, but I am enjoying the location, that's for sure. Willsbar, Pennsylvania, DC. Yes. All right. So let's get to the questions. Thank you for joining me tonight, guys. I hope that I'm helpful. For those of you that are new, my name is Carmella George. I'm a VA Accredited Claims Agent. What that means is that, sort of like you know about the American Legion, DAB, VFW, they are accredited as groups by the VA, groups to do claims, and they individually accredit their members. But I'm individually accredited as a single individual to prepare, present, and prosecute claims before the U.S. Department of Veterans Affairs. And that's what I do every day for a living, and I absolutely love it. It's my passion. I love helping veterans. I love seeing veterans win and succeed and get the compensation they are due and that they were promised when they enlisted or became an officer in the service. And so it's my absolute pleasure to be able to help veterans and spread the knowledge I've learned from my time doing this with you all to help you win your claims. I do this, I offer this service, this monthly live, as a way to help the most veterans possible, because it then lives on my podcast and on YouTube forever. And a lot of veterans go back and watch it and they find useful information that can help with their claims by the questions that you ask. So just know that you being here and you asking your questions is going to help a lot of veterans. So I thank you for your time. I thank you for tuning in, and I thank you for your support. So let's jump right to it. All righty, we have our first question of the night is, I was denied service connection for sleep apnea. I submitted a supplemental claim with the DBQ and Nexus. Now are they requesting another CMP records review? Is this normal? This would be the third CMP exam. My goodness. The answer to your question is yes, it's normal. Unfortunately, it is normal. It's the norm for the VA to order more exams after you submit a supplemental claim, even with the Nexus and DBQ. But my personal answer would be it should not be the norm, because what the guidance says is that you probably already submitted sufficient evidence And the guidance tells them that when you have submitted sufficient evidence, there's no need to order further examination. There is still, and I'm glad I'm starting tonight off with this topic, because I've been sort of frustrated with it all week with my clients, and what I've been seeing in the system is that there's still very much a bias at the regional office level among raters and DROs, decision review officers, against private medical evidence. It's ridiculous, it's unnecessary, it's unlawful. The law says that all evidence is to be given its proper probative weight, which means it should be reviewed and evaluated on its own merits, how it stands to everything else of the record, and that the whole recorded history should be taken into account. And so there are a bunch of unnecessary exams being ordered. I see it every single day. Sometimes I have to push back and fight against it for my clients. They're the best I can, and they still move forward with the third or fourth or fifth exam. That's unnecessary. And then sometimes they do what they're doing in your case, which is an ACE review, where you won't be present. It will just be an examiner reviewing the record, and hopefully they review the record in detail. CMP examiners are not known for reviewing the record in detail. We all know, are reviewing every record in the file. And so these contract companies sometimes have minions that just pick out of your record what they think the doctor should see and the examiner should see, and then the examiner looks at it and makes a decision on part of the evidence. That's totally, not every company is doing that, but that's not how it's supposed to work, but that does happen. So I would not count on a CMP exam being more accurate than the evidence that you presented. That's my take. So yes, I'm a little peeved with the way there's a bias against private medical evidence. I'm making it known here. And you probably should not be having a third CMP exam, sir. I'm sorry that's happening to you, Mr. Phillip. But there's little we can do to push back against it once they order it at the regional office level. Now, if your claim ends up getting denied or something like that, you could go on to the board, which is one option, or you could go back to the supplemental claim route or higher level review. But going to the board, you would have one argument that there was development to deny, that they took unnecessary action to order another exam that wasn't needed, and they denied based off that exam. That unnecessary development is what we call in advocate land, development to deny. So very good question. I'm sorry that's happening. And unfortunately, it's normal, but it should not be. I received 100% P&T from the VA. However, I looked at e-benefits and it says permanent and total RFE. I'm confused and I don't understand. I got my final letter saying everything. I'm P&T. I looked at e-benefits. I would in this situation, it is my opinion that e-benefits is probably has it listed wrong. RFE means routine future exam. So you can't both be permanent and total and have routine future exams. If the letter told you were permanent and total, if your rating decision letter told you were permanent and total, that you were entitled to dependents educational benefits, and the letter said you were entitled to educational benefits, and the letters you generate now from va.gov say yes, you're permanent and total, then you're permanent and total. The way you could shore that up is either by calling the 800 line and just asking them, hey, are any future exams scheduled for me on my rating code sheet? Or by getting a copy of that code sheet yourself, what's called your rating code sheet, where all the diagnostic codes are listed for your conditions. It will tell you if those disabilities are static or not. If they're static, that means they're not scheduled for any future exams. But if a future exam is scheduled, that sheet will tell you, and that would mean you're not permanent and total. Now, if you happen to in the small event or small possibility that you get that rating code sheet and it says you are scheduled for a future exam, but then on the other hand, somewhere at the bottom, it says you have Chapter 35-2, dependents educational benefits, that means somebody has made a mistake. And you need to move to probably get a representative or get a VSO and some help and get that corrected ASAP. So in 10 years, 10 years, they're not scheduling you for a future exam when you're permanent and total and you're not supposed to be having one. Hopefully I've been clear, but It sounds like you're permanent and total and you don't have anything to worry about, and maybe benefits is just reading wrong, but you do want to make sure at this point, so in 5 years, you're not surprised with some unnecessary exam. Shout out from Magnolia, Texas. Hi, Mr. Holland, how are you? Hello, Carmella, you are the queen bee. Oh, thank you, truly Dreams Live. Oh, thank you. I thought that was a question, but thank you so much. You guys are so kind. It's my pleasure to provide this service and answer questions from y'all. All righty, we got Marshall, Texas in the house, Washington, Palm Tree. Okay, I've seen some of these. Let's see. Here we go. Hello, thank you for all that you do. Thank you for your service. Question: I received a denial for sleep apnea. I did a sleep study soon after getting out the military and have a CPAP. What can I do? What evidence can I submit? Okay, so I would need to know just a little bit more to advise accurately, the most accurately on your question. But you need to pay special attention to the reason why they denied your sleep apnea. It's if you claimed it based on direct service connection, which means directly related to service, then there's probably one of three reasons why it was denied. Either they're saying an event didn't occur in service, which is what I suspect is happening. They're saying there's no chronicity between the event and service or in the current diagnosis you have now, or they're saying you don't have a current diagnosis. It's one of those three things. And so I suspect, since you got the sleep study soon after you got out, that they're saying there was no event in service. One of the things you could do is fill that gap with lay testimony and the witness statements. Get as many as you can. Write your own statement about what happened, about the issues with sleep you experienced on service. Resubmit a supplemental claim or take it to the board, because you can't present new evidence during a higher level review, and try to go about it that way. That's one angle. The second angle is to try to attempt to get a sleep apnea service connected as a secondary condition. That will be secondary to something that you're already service connected for. So a lot of people go sleep apnea to PTSD. I see sleep apnea to secondary to asthma or other respiratory conditions a lot, like bronchitis and other things. I'm not a medical professional, so I can't tell you for sure that that is a valid connection, but these are things I see in the life of doing disability every day. Sleep apnea secondary to TMJ, sleep apnea secondary to allergic rhinitis, sinusitis. I even see it secondary to some joint pain, where the joint pain has caused you to gain, significant weight because you are immobilized and can't exercise like you used to. So there's many things that sleep apnea can be secondary to, which means it was caused by another condition that's not service connected was caused by a service connected condition, but you have to specifically claim it as secondary. That's a different claim than a direct service connection claim. And so if you don't know exactly how to flesh that out, you might want to seek some competent representation in the VSO. That's probably all you need at this point. Although there has been a denial, so an agent or an attorney could help you too. But what you don't want to do is get somebody that's going to drag your case out when you could probably get, some answer in 3 to 5 months, going the supplemental claim route with some other significant evidence or a new theory of service connection. So hopefully that's helpful to you. Pensacola, Florida, Bay Area. Where's the Bay Area? California? Yeah, California. Jacksonville, Florida. Hey, y'all. Hey, y'all. Okay. I recently got SSDI based on my service-connected disabilities. Can this help me with the TDIU claim? Okay, so they're not going to make the TDIU decision based solely off the fact that you were granted SSDI, but the good thing is all those SSDI records, either you provide them to the VA or let the VA know that they exist, and the VA is going to certainly request them because they're federal medical records or other federal records, and they can be used in the adjudication of your claim, which means the rater will weigh them and the examiner will examine them and come into their conclusion about whether you meet the requirements for TDIU. So one of the good things about TDIU and its adjudication is that the law provides that they take into account the whole recorded history of the veteran. That would include your SSDI evidence and everything that was gathered in the process of you being granted SSDI. So those records will be used in that decision. And so in some ways it will help, yes. Ohio, Melbourne, Florida, Hickory, North Carolina. I know where that's at. Oh, wow. All the way from Puerto Rico. Thank you for what you do. Yes, sir. Yes, ma'am. Arlington, Texas. South Carolina. Wow. Warner Roberts. I got a few clients from Warner Roberts. Mobile, Alabama. Oxford, CA. Let's see here. DC. I love DC. I used to go there all the time. All righty. VA rated 40% for fibromyalgia. VA letter states additional symptoms include headaches. VA denied headaches. Shouldn't headaches be separate? It can be. The answer is should it? It would be what would be dependent upon your record. But can it? Yes. And should you pursue it separately? Probably. But I have not reviewed your record, Ms. Linda, and I can't tell you for sure. Now, if some examiner is saying that headaches is a symptom of your fibromyalgia, they're not going to rate it separate. It has to be a separate primary condition. But that's just one examiner's opinion. You could easily get evidence that would likely refute that. So this is why I'm saying I would need to review the record, and you would have to pay close attention to the facts of the record to determine whether it should have already been separate and you need to ask for a higher level review, or maybe you need to provide some additional evidence and submit a supplemental. Wow, lots of questions tonight. Whoa. Okay. Good evening. Put in a claim for Parkinson's. Oh wow, sorry you're going through Parkinson's. Can be an ugly disease sometimes. But hopefully you have the evidence that proves it, or either you're a Vietnam veteran or somebody from an era where it is presumptive, and I wish you the best in your claim. Do you have offices in South Carolina? Myrtle Beach, South Carolina? No, I'm just playing. I have offices wherever the beach is. That's the truth. I love the water. There's something spiritual about the water to me. I enjoy working by the water, so I make my office frequently wherever the beach is. But no, I'm just playing. I only have one. My headquarters is in Jacksonville, North Carolina, by Camp Lejeune. That's where my only business office is located. But I frequently work off-site. And so it's probably not a good idea to just stop by my office without talking to me first, if you're trying to locate me on the earth. But because I do travel frequently, but I do not have primary offices in South Carolina, no, sir. I just am there often at Myrtle Beach. Maryland. Myrtle Beach is about an hour and a half from me, from where I reside. So it's a pretty cool destination to go to. Lots of stuff to do there. Maryland. I have been there often too. I had an informal conference for my HLR today. How'd it go? Tell us how it went. Give me another comment. Tell me how that HLR went. I'm finding that with many veterans and HLRs, there's an attempt to introduce new evidence, and you can't introduce new evidence in the HLR. And sometimes you're needlessly taking the HLR route when you should probably be pursuing a supplemental claim with your HLR. So I'm not saying that's your case. You probably did a great job at your HLR and knocked it out the ballpark. But I'm just putting a notice out there for other veterans to make sure you're choosing the right appeal lane, the best venue for your appeal, so you don't end up just wasting unnecessary time. Some people feel or think that the longer a claim takes to process, the better the outcome will be. I'm pretty neutral on how long it takes. I don't think time has much bearing on the outcome of a claim. That's not a pattern or practice or consistency I see among the VA. So I can't validate that idea. I can see why some people think that, but that's not something that I've been able to validate from my experience doing this professionally. And plus, I'm in the system daily looking at thousands of claims. And so in different situations over time. And so I don't think that the longer a claim takes, the better the outcome will be. Time is not a good indicator of the outcome of a claim when it comes to the VA. There's lots of times where there's lags in the system, technical issues, where the claim is just not pushed forward in the suspense date when it's supposed to in the system, and other things like that just cause unnecessary delays, where your claim is just really sitting in nowhere land. in the system is called regional office, or not regional office, but station 499. That means nobody has assigned your claim, nobody's working on it, and it's just out there in nowhere land. And it's sometimes claims sit there so long and don't move forward that it has me scratching my head and watching paint dry. And so, the longer a claim takes can be just an indicator that there's a systematic issue, or nobody has touched it, or somebody put a suspense date that's too long on it. There could be a whole host of problems or issues of why your claim is taking longer. It needed additional evidence, just various reasons. So the time frame that it takes is not an indicator that your claim is going to get approved. And that's not an assumption I would make. Don't get your hopes up just because your claim is taking a long time. That's basically what I'm trying to say. Wangram, North Carolina. I've been in North Carolina most of my life, and I don't know where that is. Wow, Wangram. Got to look that up. Miss Long, Mr. or Mr. Long. Miss or Mr. Long. Grand Prairie, Texas. Wow. Dominican Republic. Oh, I love it there. I love it there. I've been to Punta Cana one time. One of the best resorts I've been to down there, the Royalton. Winter Haven, Florida. Oh, hi, Mr. Holiday. Hope you're well. Okay, here we go. Thanks for all you do. Question. I already answered that. So I already answered that question. Dothan, Alabama. Here we go. Sleep apnea. When do you think sleep apnea and CPAP disability will go away? Honestly, I don't think that it's going away. I don't think that it's ever going away because it's a disability itself. Sleep apnea is. And VA disability accounts for most disabilities, unless it's just a lab reading or something that's not considered a disabling condition. For instance, the VA does not consider obesity to be a disability right now. Now, there's some court cases and other things like that happening, and some litigation and legal action that might change that in the future. But right now, the VA doesn't rate obesity. But that's not the same thing for sleep apnea. Sleep apnea is a known disability. Millions of people have it. I don't see it going away. Now, what I think what you're referring to is the proposal by the VA to rate it differently, where most people would probably get a little bit of a lower rating than 50%. Either it looks like most people would rate 0 or 30. And so the question is, will the final rule, the final situation or laws on the rating schedule look like what the proposal that the VA proposed before? Will it look the same? And my strong suspicion from my professional experience is that it won't. There were so many comments, so many negative comments against it, so many professional groups, organizations like American Legion, DAV, NOVA, attorneys and veterans, lots and lots of veterans themselves that spoke up and say, hey, VA, what are you doing here? This is not right. You need to pay attention. This is going to hurt veterans. This is a real disability. It can lead to death. It can lead to a lot of other things. It substantially affects the quality of life. Sleep apnea does. I mean, sleeping with a sleep app is not the sexiest thing in the world. Let's be honest. And so it affects quality of life greatly. And so I don't think that the final rule will look like what the VA initially proposed. That's my strong suspicion, hunch, and prediction. But I can't, that's for the VA to work through. But your real question is about time frame, will it go away? And the answer to that is it's going to take many, many months to possibly years, 1, 2, 3 years before that final rule comes out and we know what the sleep apnea ratings will look like in the future. Is they have to work through every single comment that was made, and there were thousands of them. And so and they have to give an answer to those comments, or they have to group those comments together and give an answer to them. That's the way, changing the basically the law on the administrative side works. They have to put it on the Federal Register, receive comments, work through the comments, and adjust the proposals as necessary. So there's a process that will take some time. We don't know when it will go away, when that final rule will be issued, or what it will look like. So it's going to be very, very interesting to see. We're certainly in for a ride. Would a late statement from a spouse describing symptoms for something that is already service-connected? It could help if you're talking about getting it rated higher in severity. Certainly a witness statement about what is happening each day and what somebody else is witnessing could help sway the examiner and the rater, yes. Denied secondary cervical radiculoscopy to my neck strain. CMP doc wrote it was due to my DDD and not strain. But my code sheet from 2020 approved claims said 5242, which is DDD. Won't I win an LHR, HLR, higher level review? Well, it certainly seems like you have a winnable situation, and it's about the argument you make and the fine details of your claim. Now, I'm not a medical professional. Let me lace this with that. I'm not a medical professional, but the argument that your radiculoscopy is due to your strain and not which is more of a muscle situation, possibly, than a joint condition. I could very well be wrong on that, but it seems like maybe that's a soft tissue type of thing, and not a joint condition could be made. It could just be that they needlessly parsing the disability and splitting hairs when they don't need to. And hopefully the higher level reviewer will see that. But if the medical argument was made that your radiculoscopy is absolutely not due to the strain and it's only due to the DDD, and the DDD is not currently the diagnosis that the VA has listed as your disability, then you may want to present alternate medical evidence in a supplemental rather than requesting the HLR. It might not be a winnable HLR. I have not reviewed your file, and so I can't tell you for sure. But it sounds like you have a shot, but it's all dependent upon the fine facts of your file, and you need to pay very close attention and making sure you're making the right argument at your HLR. I see so many veterans that request HLRs that aren't making the right arguments in them, or like I said earlier, are attempting to introduce new evidence when that's not the purpose of an HLR. In an HLR, you can only argue the evidence of record. That's it. You cannot present new evidence. You only can present new arguments. And you need to know how to make a legal argument and what the legal error was, the duty to assist error was, or the due process error was, and argue that. Hey, what about the Camp Lejeune contaminated water? This is a very good question because there are a ton of people asking me and my clients, because I live in the Camp Lejeune area currently, asking me about this lawsuit and what's going to happen with the PACT Act and how it relates to VA disability and that type of thing. So I'm going to give you my understanding of it as it currently stands. The PACT Act is dealing with a technicality issue in Congress where the Senate tried to introduce a tax provision and the version they passed. And so it went back to the House. The House said, hey, hold up. You can't do that. The Constitution says all tax bills must originate in the House. And so the Senate has to fix their bill, send it back to the House. The House has to pass it before it goes to the president. Once all those technicalities are wrapped up, the president's going to sign it and the PACT Act is going to become law. And it does not look like any of those technicalities is going to prevent the bill from passing. It looks like the bill is still going to pass, according to all the sources and everything that I've read that cover this stuff regularly and are way more well-versed than I am in the politics and how Congress works and all that. Certainly looks like the bill is still going to pass. In that bill is what is called the Camp Lejeune Justice Act. What has been, it has gone around for years, which allows people to get around the North Carolina statute of limitations on filing claims, tort claims or claims against the government or claims and that type of thing. It allows you to get around the statute of limitations and file claims about within a 2-year period from the date that legislation is passed. You have 2 years to file a lawsuit that you were harmed by the Camp Lejeune water. Now, there are many law firms already advertising that they will be participating in filing class action lawsuits against the government on behalf of the people that lived, worked, were part of the military, that experienced the Camp Lejeune water and have been negatively affected by it. There are many, many law firms advertising right now. My thing is, and what I want veterans to know, It is my understanding. Now, this is Carmella's version from reading the text of the bill and from talking to some attorneys about it, that if you are to participate in a lawsuit and you take a lump sum payment from the lawsuit, this is important for every veteran to understand that was affected by Camp Lejeune water. If you take a lump sum payment from the lawsuit, the VA is going to hold your monthly check until that lump sum is paid back. They're going to take, you can either have the lump sum from Camp Lejeune or you can have your VA disability. That's the way the PACT Act reads at this point to this date, from Carmella's understanding. I could very well be wrong. I could be reading that wrong, but I have conferred with a couple folks about it and they agree. So veterans need to understand before they get in it that you could potentially be setting aside your monthly check for some time. Now, that could be perfectly fine for some people. Some people prefer the lump sum to the monthly check. But what happens is, what my fear and what's going to happen in a lot of cases is people are going to get that lump sum without knowing that the monthly check is going away and spend that lump sum too fast and then be left without their benefits. And so just make sure that you're aware before you sign that contract with the law firm, that you're aware of all the ins and outs of possibilities of what might be happening. Just like any other thing in life and any other area of life, before you sign a contract, read every word, understand what you're getting into, and understand the implications of what might happen to your VA pay from an outside lawsuit. That's all I'm saying. It could be a very good thing for some veterans that aren't service connected, but for veterans that are service connected, please pay attention. The first question that hits home: I have struggled with the VA and Carmella had fought hard, and we are still playing the game for over a year now. Yeah, some cases just take time. But I'm in there with you for the fight, and hopefully we win. I don't really know who that is talking. Hi, I have received 100% back in March 2022 for PTSD and MDD alone, but not PNT. How long of a wait to request PNT? Thank you. As soon as they made a decision in March, you could have requested PNT the next day. You have to make that decision and that call based on the evidence of record and its relation to when the next future exam is scheduled, and what you think is best for you. Do you want to go ahead and go through another exam for that 100% PTSD, MDD, that 100% mental health rating? Or do you want to wait for the routine future exam? Or do you have evidence to present that would prevent you from having another exam that proves your disability is permanent and total? There's a lot of various factors to weigh there and decide whether you want to go ahead and request PNT or you want to wait for the routine future exam. If all those things confuse you that I just said, and you're not sure how to make the decision on your own, you might want to enlist an advocate, at least a VSO. Would it benefit me to request for a temporary increase for PTSD? I'm currently rated at 70% for PTSD, but was shot in the line of duty from an officer involved shooting and wondering if this would have a negative effect on my current rating. There's a lot to that question. First of all, I'm sorry you were shot and you went through that. Are you currently in the Guard or Reserves, and is the shooting new, or was that the basis of your PTSD rating? And there is no temporary increase for PTSD unless you're on convalescence. You've been hospitalized for it for over 21 days, or in some type of inpatient care for over 21 days. So I'm not sure what you mean by temporary increase. That's not necessarily a thing in VA disability unless you're experiencing convalescence again, which is some inpatient care over 21 days, basically. So you might want to get with me offline about that, and maybe I can answer your question a little bit more in depth because there's some facts missing that I would need to answer this correctly. But temporary increase is not necessarily a situation that applies given the facts that you rendered there in that question. Thank God for you calling things in question and being able to speak out witness to the wrong that is going on. Yeah, I've been very vocal about some things that I see on the inside of the VA. On the inside of the VA, I don't necessarily do it on my public platforms, but just know that any way that I can speak up when I see something, I'm doing it. And that doesn't necessarily make a lot of people happy at times, but it is my duty, I feel like, as an accredited professional, to let the top know what we see every day in the trenches and on the ground. And there are some different things with contractors and stuff that I'm seeing and other my colleagues are seeing that we don't like, that I speak out on. So you guys just know that you have an advocate in me, and that these issues that I see with VA benefits, I make it known that they're going on. So that's one thing that I do. Here we go. Is it difficult to get service connected for PTSD, MST, without any documentation reports at the time of the assaults? Only have buddy statements. Can you please provide advice on getting a positive outcome to a claim? Given that you have buddy statements of the assaults and the events surrounding the assaults, it should not be as difficult. Now, let me put it this way. To be frank, the regional office gets things wrong all the time. About at least over half of the decisions I see, I feel like have some type of error in them. Sometimes even when they're positive and approved, they have errors with effective dates and other things. So getting a claim through without some type of error being committed on the regional office parts is almost a rare occasion anyway. But so is it difficult to get service connected for PTSD without any documentation or reports? It's about as difficult as any other claim without documentation. I mean, you're fighting an uphill battle already. But I'll say that I've said before, I'll say it again. I strongly believe that the biggest factor in PTSD MST claims is truth. If you are telling the truth, I believe the truth will prevail. I'm not trying to phrase this in a way where I mean that most people that claim MST aren't telling the truth. I believe people's stories. I do. But I'm saying that as long as you're standing on the truth, you are fighting the good fight, and I believe you will eventually prevail. It's about getting the VA to listen. It's about providing the right evidence, even though it wasn't documented. Here are the markers. I lost a lot of weight in service. I was transferred to different units. I had performance issues, or I did my job to the very tip top best of my ability, so they couldn't let me go or admin separate me. I was always pushing to be the best, so they couldn't find anything on me, because we all know when you mess with powerful people retaliate. It's just what happens. It shouldn't happen, but it does. So you have to tell your story, show in the record, even though it wasn't documented, where some changes happened. Did you start drinking? Did you start having marital problems? What happened? Can you show some type of change or some type of issue in service? Maybe even if the assault wasn't documented, that would make your hill easier to climb. So that's my advice on getting a positive outcome on the claim. Just connect the dots for the reviewer and the examiner in writing. Provide all the buddy statements you can, and provide your detailed stressor statement. Can you discuss attorney and accredited agent representation in the supplemental claim lane and HLR lane? It seems many veterans seem to think hiring an advocate means it will be drugged out to the VA for years. Okay, so this is an interesting question. Let me get something to drink before I answer this one. This is a very interesting question, because I'm not going to beat around any bush and not tell you the truth. I'm a plain talker, straight shooter, and I'm just going to tell you like I feel like it is. There are some agents and attorneys that will drag your case out for years. I'm not one of them, and I know a lot of my colleagues aren't, but there are some. Okay, that's the truth. But I think most representatives, the greater majority of them, don't do that. I think they take the appropriate route for your claim, and they try to win it at the earliest point possible. That's what I think of most representatives. It's true. That's Carmella's perspective. It's not based on any stats or facts. Well, it's based on the facts that I see, but you might have different facts from your perspective. But I think that getting an accredited representation is a claim is usually the best way to go. The stats at the BVA do show, I don't know, the regional office puts them out to the same degree, but the stats at the BVA do show that those that are represented by an attorney have the best probability of winning. Next comes an agent, and then next comes a veteran service officer representation. You have a much better chance of winning than on your own. So it is to your advantage to be represented. I think in the supplemental claim in the HRLR lane, I mean, my strategy is always to win at the win the highest benefit in the fastest amount of time possible. I don't play around, when it comes to just putting a claim in the BVA hearing lane for 5 years and making the veteran sit there and wait. I don't think that's an effective strategy. I don't think it creates a happy client, and it doesn't make a happy agent, because then I have to wait 6 years to collect the fee. And so the honest answer is that it's to all of our benefit to get this resolved in the fastest time possible. And that's what I think is true of most agents and attorneys and VSOs who do it for free, but they want to, they don't want the stuff on their plate for 6 years, because it just weighs the log down and they can't help other veterans. So those that think that it will be drug out for years just because you hire somebody, I don't think that's the larger truth. I think it's true in some situations, just like anything else. Hopefully that was helpful. I am at 90% and rate 10% for my lower back. I just had back surgery on June 29th. What does the doctor have to write up so I can receive temporary 100%? I will be out for 8 weeks. They just need to give you a work note that says you're out of work for 8 weeks. You submit that with a request for temporary 100, temporary convalescence based on your back on a 526 EZ form, the original application for benefits, or on va.gov, submit for convalescent pay, and you should receive that temporary 100% for the time that you're out of work. Good question. Annie Barnes, Lumberton, MC. Hi, Miss Annie. I know where Lumberton is all too well, out there by Fayetteville. You're going to see Pembroke. Okay. Hello from Oakland, Tennessee. I didn't know Tennessee had an Oakland. Thank you for your time. You're very much welcome. Hello, I'm 100% and I have an upcoming CMP exam for claims I filed for previously. Should I go to the exam and would it affect my rating? This is a loaded question. You're already 100% PMT, and apparently there are still claims outstanding that you filed for previously, or maybe were previously denied, or that you filed for previous to becoming 100%. Okay, I get it now. Should I go to the exam? I would say if you don't feel like it will harm anything you're already rated for, or the things that made you 100% PMT, you're not being re-examined for any of that, I would likely go to the exam. And will it affect your rating? If any of those exams are for things that make up that 100% PMT, it might affect your rating. So you have to weigh what is the best route to take care based on your knowledge of your record. What can he do to get it permanent? I assume you're talking about the question where they were asked about the routine future exam and the rating not being permanent. In order to be permanent in total, number one, you have to be either IU or 100%, have some form of 100% rating, whether that's IU or 100% scheduler. That's the first step in becoming permanent in total. You have to be being paid at the 100% level to be permanent in total. The second thing is if you're 100% scheduler and they have not made you permanent in total, and they've scheduled you for something, one of your conditions for a future exam, then what you need to do is make a request in order to be permanent in total. It's not what you need to do, it's what you may want to do. In order to become permanent in total, there's a provision in the M21 manual which is the adjudication protocol for raters on how to actually work claims and perform claims, how the regional office is structured and work. It's very good reading material if you ever have the time. It's available online at like nova.ebenefits.va.gov, I believe, or you can just Google it. The M21-1 procedure manual for the VA. Google that. If there's a provision in there that it says how to request permanent and total, or PNT, follow those instructions. What it says is that you need to request it on original application for benefits, that you're just simply requesting permanent and total. But know this, whatever condition that is scheduled for a routine future exam that is keeping you from being permanent and total, even though you're 100% scheduler, you're going to be scheduled for another exam for that condition unless you present evidence, so enough sufficient evidence that an exam does not have to be scheduled for it. So yes, you can request permanent and total, but know that it's likely going to come with another examination. That's the peril of it all. And so you have to weigh whether you believe that you won't face a reduction or anything like that by pursuing PNT. What the likelihood of reduction is, I can't tell you for every condition, or it depends on the facts of your file and the severity of your condition. So at some point, somebody thought your condition might get better, at least one of your conditions, and that's why you're just 100% scheduler. And so you have to provide evidence to the contrary, or either go to another exam that shows the contrary. That's both the advantages and disadvantages of putting in a request for permanent and total when you're at the 100% scheduler rate. What would I be able to claim degenerative disc disease and arthritis secondary to lower lumbar strain with evidence from MRI and X-ray, or would it be best to go after an increase? Okay, so this is the thing. Once you are rated for a back condition, lower lumbar strain, it's not necessary to pursue different names for a back condition. You're already rated for a back condition. What you want is either to present a supplemental claim that shows that your back condition is rated at a higher level. That would mean that you likely submit a private DBQ with the supplemental claim application. So you get back paid from the date you first got rated for the back. If it's within the last 365 days of the claim, or since COVID started, you can get back paid because of the COVID extension. Or you could go after the increase and get a new CMP exam and go higher. So don't worry so much about the nomenclature, what it's called, the back disability. Worry more about the date that you could get back paid the furthest for if you were to submit a private DBQ, or if that's not an option for you, if you could just put in for increase, get another exam and go higher. If you're only at 10% for the back, you could probably go to 20 or 40. If you're at 20%, you could go to 40. If you're at 40 and you are on bed rest for a significant period of time throughout the year, you could likely go to 60. But that bed rest is not common for most veterans. So you have to weigh which option is best for you. But worrying about what your back condition is called at the VA is usually a needless fight. What forms are needed to submit to the regional office once the judge grants unemployability at the 100% and an increase in the knee condition? If the claim was from February 2006, would I get back to the effective date? Once the judge grants it, it's already going to go back to the regional office. The regional office is going to open a new claim. You're going to see a new claim open up on va.gov within a couple of days of the board grant, where they're adjudicating whatever the judge told them to adjudicate. If it's granted unemployability, they're going to issue a rating decision that does that and the increase in the knee. If they need to order a new exam, they're going to do that. But they're going to do whatever the BVA told them to do. They don't need any prompting from the veteran to do that. It's going to happen. So will you be back paid from the February 2016 date? Most likely, because you continuously pursue the claim. But I've seen some things happen where they just rate it from the date of the exam and different they get effective dates wrong often at the regional office. So if they don't rate it from February 2016, pay very close attention, go back at them, don't let it sit, keep appealing until you get the right date. Alrighty, is IBS, sleep apnea, PTSD secondary to chronic asthma? It could be. It could be. I've seen it before. How tough is unemployability for a 70% veteran PTSD? What is needed? It all depends upon the facts of your file and the severity of your PTSD. What is it? Is it debilitating? Is it keeping you from working on a daily basis and for the rest of your life? If that is true, then it's likely not that tough. But if that's not true for you, you might have a certain hill to climb if you can't relate to the examiner the severity of your condition in a way that would make them believe the fact that you can't work. So that's what you're fighting against, and that's all you need. You need to convey your disability in a way and in terms that would lead the examiner to believe that you're unable to work for the rest of your life. That's what you're facing. Okay, let's see here. All right, guys, we got a ton of questions tonight, and I got a little bit more time. As you can see, it's getting dark here, and I'm probably gonna have to wrap this up soon. But I thank y'all for joining me, and I'll try to get some back to some of these questions, separately at a later date. Okay, here we go. I know some of my answers have been long, but hopefully I've been helpful. How would hysterectomy be service connected? I had cysts in my ovaries in the military service. So if you feel like it's a result of those cysts in your ovaries during the military, you just need to claim it secondary to that as a residual or something like that. Are you rated for the cysts in the ovaries? If they're at least 0%, claim the hysterectomy secondary, or claim the hysterectomy direct, but make clear in your claim in the sections they ask, how is this related to the military? That you write it's caused by the cysts that I had in my ovaries in the military that are documented in my STRs. When will you be near or in Tampa, Florida? That's an interesting question. My sister flew out to St. Augustine today, Florida, and I don't know when the next time I'm scheduled to be in Florida is. I feel like I have to be in Orlando for something before the end of the year. Oh, I'm going to Orlando for the Veterans Day cruise to fly out to Bahamas. So I guess I'll be there in November. That's an interesting question. Hi, I have tried to connect through one of your forums, but it said you were not taking clients. Are you taking clients at this time? Okay, so I'll just put this out there and answer this question for everybody. I'm not taking new clients at this time. I had planned to do so in July, which today was supposed to be the day that I started taking new intake. But in April, I was dealing with the extended illness. I had a severe allergic reaction, and it just kind of flipped the script for me for a couple months. I'm really just getting back to feeling like myself. I was quite sick for a couple months. And so I am not taking new clients now so I can work through my current clients and devote my time to some of the work that got behind while I was dealing with an extended period of illness. But I do plan to open intake back up in October. And I would be happy to look at your case then when I do open up intake. Hopefully it's October if I get caught up. But thank you for your interest in my services. But at this time, I'm going to be listing very soon a number of different representatives that I would refer out to during the time that I'm not taking clients. I've been meaning to get it up, but it's just not the first thing on my list to do. So hopefully I put that in the next week so you all can see some different options for, getting proper service, people that I would stand behind their services. So, I'll be listing that on my website. But thank you for your interest in my service. But it's just that I'm not taking clients at this time due to an extended period of illness. But thank you. How do I refile a case for incidental enterotomy? Incidental enterotomy where they accidentally cut my bowels. Oh, wow. The VA denied my claim, stating they could not find my record. I would get some statements, or who is they? Was it the military or was it the VA that accidentally cut your bowel? That's the first thing we need to establish. Because if it's the VA, then that's a 1151 claim, sort of like a tort claim, but in VA language. And you need to get the VA records, request them, and submit them with your claim. If it's the military and they can't find the service treatment records, you then maybe try to track down the hospital that was done at, or the surgeon that did the surgery, and try to get a statement or get some records or get some buddy statements that happened. But even if that happened, it was so severe that caused that kind of condition, even a doctor now should be able to attest to the fact that your bowel was accidentally cut during surgery and you're still dealing with the residuals. That's what I would think. So you might want to get a current doctor statement about the condition and the residuals that you're dealing with, and when that incidental endarterectomy might have happened, and submit that as evidence with a supplemental claim. Because if that happened, they should not be denying your claim by any means. You also maybe want to ask for a personal hearing at the regional office level, where you can sit down with somebody, not eye to eye, but you can look at, now they do hearings on Microsoft Teams virtually. You can look at them on video eye to eye and tell your story. I think regional office hearings are a weapon that not enough veterans, are claims weapon that not enough veterans take advantage of. It can be a powerful tool to look the person that will be making the decision in the face and tell your story. It makes them pay attention. It forces them to look at the fine details of your case that you bring up in the hearing. And sometimes when they keep needlessly denying your claim, it's to your advantage to request that hearing before they make a rating decision. Yes, you will have to wait a little longer to get the hearing, probably a few months, but it will probably help you get a denial where you're not waiting 3 or 4 years to get before the board or a judge. So would I wait the 3 months for a hearing at the regional office instead of waiting 3 years to see a judge at the BVA? Certainly. That's a step I would take if it was my claim. I'm currently 100% PNT. With submitting a claim for ED possibly open the door to have my other disabilities reopened? It should not, Mr. Marquez. It should not. VA keeps jerking me around. I've been going to CMP exams for the same military-connected disability since 2005. I called the White House hotline and got a case number. Does this usually make things move forward? In some cases it does, in some cases it doesn't. It really depends just on the influence of the person at that White House hotline that picks up the phone, if they know how to get things taken care of, how to make some noise and wrap things up. But otherwise, get your rep involved, have them talk for you, and get the errors corrected. Howdy from Connecticut. I got a lot of family in Waterbury. Oh, that's Doug. Hey, Doug. Hi, I currently have a BSO who's retiring soon and has already relocated. Are you accepting new clients? I think I just answered that. I'm so sorry, but I'm not at this time. But I will be listing within the next week a list of people. I should have did this a couple months ago, but a list of people that you can turn to that should be able to help you. HRR informal, it went well. It was on a queue. I won my first queue with retro of 1,000. Laugh out loud. Queue for seizure effective date back the year 2000. Looking for TDIU. Adjudicator said I should hear back in 2 weeks. So that's a bit scary. Oh, I'm glad it went well. I'm glad the HLR informal conference went well and you got somebody to pay attention. Winchester, California. Wow. Wagram is on the south side of Rayford. Oh, I know where Rayford is. Okay, gotcha. Does the VA only approve claims if there is a complaint, episode, or diagnosis documented in our active service medical folder? No, that would not be the case. Is it better if it's documented? Is it easier if it's documented? Yes, but it does not have to be documented. To the alternative, case law actually states that the M21 currently states that the absence of a documented disability or diagnosis in the active service treatment record does not mean that the veteran wasn't in pain or the veteran didn't have a disability during service. Some people just don't go to the doctor. That's true. It could be true that you had foot pain in service, but you never saw a physician. That can exist. So the VA recognizes that, case law recognizes that, but it makes it all the more harder when you don't have documentation. So is it a harder claim without documentation? Yes. Is it easier claim with documentation? Yes. But no, it's not that there has to be documentation to get approved. All righty, guys. Well, I've been here about an hour. It's been so fun being with you all. Thank you all for joining me. Thank you for your questions. I truly appreciate your service to this country. We just passed the 4th, and all the freedoms that you provided me and my family and ours and everybody else in our group. Thank you so much. Thank you to your family members who served beside you. And I truly appreciate it in a heartfelt way. And thank you for joining me tonight. Thank you for your support. So I will be back next month doing the same thing. I'm going to put out a live schedule for the rest of the year, but I'll be back probably the first Thursday of every month for the rest of the year. But I think I'm going to switch the time from 8 p.m. to 7 p.m., just a little tad bit earlier. But thank you all for joining me. It's my pleasure to answer questions for y'all. And y'all have a good night and take care. Thank you.